Welcome. This short video will help you to become confident and effective as a litigant in person. I am Bond Solon. I am a solicitor and the founder of Bond Solon Training, a company that helps people become familiar with the process of speaking in court. Today we will focus on how you can be confident and effective as a litigant in person. So what is a litigant in person? A litigant in person is someone who's going to court and does not have legal representation. When a litigant in person goes to court, their case may involve family issues, money claims, employment and debt and bankruptcy, or something else. But the principles of being a good litigant in person are the same whichever court you go to. I will explain everything in simple terms, as you may not have previously had experience of courts and so do not know what to expect or how to prepare. You may be quite nervous and anxious or have trouble focusing and getting your thoughts expressed. We will look at how to deal with these matters. So when two people or organisations cannot agree on something, they can go to a court to ask a judge to decide between them. The judge looks at the evidence of each side and makes a decision to end the dispute. The procedure is very simple. The first side gives their evidence and reasons. The second side gives theirs, then the judge decides. In England and Wales, we have what is called an adversarial system. This means the two sides discuss the disagreement between themselves, but in a very structured way in a court, with the judge making sure both sides can have their say so that things are fair. The purpose of the adversarial system is to make sure that the judge hears the truth of what has happened and can make the right decision. Part of the system allows the evidence to be tested by asking questions to get to the truth. The judge is in effect the person who controls the discussion and makes the decision based on what she or he hears from both sides. So the first thing to remember is that there is a disagreement being discussed. Each side must test what the other side says. Remember, it's quite normal for what you say to be tested, so don't worry if questions from the other side appear intimidating or direct. This is just part of the process. So let's look at preparing to go to court. Reread and make sure you're familiar with any documents you provided. Decide on the key points you want to say and practice saying them out loud, just smartly and comfortably. Double check the date and time and where the court is, and give yourself plenty of time to arrive, allowing at least half an hour before the set time so you can find your way to the right courtroom. You might want to go to the lavatory before going to court, and of course put your phone onto silent mode. On the day of the hearing, wait outside the courtroom until you are told to enter. The judge controls how the hearing proceeds, but generally one side presents their case, the other side responds, and then the judge decides. Before speaking, you will be asked to take the oath or affirmation. This is a promise that you will tell the truth, and it's very important that from now on you do tell the truth, as you may be liable in perjury if you lie. Perjury is a criminal offence. This means if someone lies knowingly, they could be sent to prison. You'll be asked to read out from a card or asked to repeat the words, but you may want to practice saying the oath or affirmation before going to court. The words of the affirmation are, I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth. If you take an oath, you may swear on a holy book or in some other way, but the court usher will explain this to you before you start. Both the oath and the affirmation have the same effect. Both are a promise to tell the truth. The judge, a lawyer, or the usher will ask you to say your full name, address, and possibly your occupation. The judge may say you may sit or may ask you to remain standing. But remember to speak slowly and clearly, as the judge will be making notes. The only person who has any power over deciding the outcome of the case is the judge. So it is the judge that you need to speak to, and the judge you need to look at when answering questions. The judge makes the decision, so speak to the judge. Do not try to persuade the lawyer or the person who asks the questions. Their role is just to ask questions so you can give your answers to the judge. As I have said, evidence may be tested by asking such questions. What you call the judge will depend on the particular court, and you can ask the court usher when you are at the court, and if in doubt, just say, Judge, Madam, or Sir. Both sides will present their information. If the other side asks you questions, this is called cross-examination. Being cross-examined can be quite challenging. If you begin to feel anxious, take a deep breath, perhaps remain silent for a moment, and focus on the key points you want to say. There is no rush. Also, remember the judge needs to hear evidence to be able to make a good decision. They want you to do well. So to review, when two people or organisations cannot agree on something, they can go to a court and ask a judge to decide between them. The procedure is very simple. The first side gives their reasons and evidence, the second side gives theirs, then the judge decides. Reread and make sure you're familiar with any documents you've provided. Decide on the key points you want to say and practice saying them out loud, just smartly and comfortably. Double check the date and time and where the court is, and give yourself plenty of time to arrive, allowing at least half an hour before the set time so you can find your way to the right courtroom. You might want to go to the lavatory before going to court and put your phone onto silent mode. On the day of the hearing, wait outside the courtroom until you are told to enter. The procedure is simple. One side presents the case, the other side responds, then the judge decides. You can practice taking the affirmation or oath before the hearing. The affirmation is, I do solemnly, sincerely, and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth, and nothing but the truth. The judge makes the decision, so speak to the judge. If you begin to get anxious, take a deep breath and focus on the key points you want to say. Please contact Support Through Court. Their volunteers provide practical, procedural and emotional support for both remote and in-person hearings. For more information, do visit their website at supportthroughcourt.org. Well, thanks for watching and good luck.